it's a fascinating time to be a lawyer, but also trying to keep your eye on the ball is just untenable, especially with the pace within which everything is going under this administration, executive orders, lawsuits challenging injunctions, no injunction. I mean, it is just a whirlwind.
Hello and welcome to Campus Docket, a Volt podcast about the legal challenges reshaping higher education. I'm Scott Schneider, attorney and adjunct professor at the University of Texas School of Law, and I'm joined by Eric Kelderman, senior writer at the Chronicle of Higher Education. Each episode, we unpack the key legal developments that matter to higher ed leaders, from student rights and faculty contracts to DEI lawsuits and government oversight. Let's get into it.
Hey everybody, Eric Kelderman here, senior writer at the Chronicle of Higher Education. Welcome back to Campus Docket. Scott, great to see you as always, man.
Thank you.
Yeah.
It's great to see you as well.
Thank you. I'm really enjoying our sessions. Let's get to some of the recent developments in legal higher education. A couple of really, I think, very interesting things this week. I want to start with what I think is one of the most stunning developments over the past several months even, which is, according to the New York Times, the Justice Department is now asking University of Virginia President James Ryan to resign. Federal investigation scrutinizing the institution's diversity, equity, and inclusion programs. I don't think I've ever heard the federal government asking the university president to step aside because of some perceived non-compliance. Scott, what are your thoughts about this?
Yeah, I mean, that is a remarkable ask. I could be wrong about this, but I think probably about 4 or 5 years ago, there was a situation out at San Jose State where the Department of Justice had suggested, hey, that the university hadn't handled sex abuse allegations correctly. And there was some hint that there was a request that the president at San Jose State would need to resign. I don't think it was this direct. I haven't read the story, and I don't know how direct the request is, but there isn't a lot of precedent for it at the federal level. Look at the state level, certainly not unusual, and it's part of an occupational hazard for university presidents that if state leaders, legislators, boards say, hey, we're not happy with the way you've handled various compliance obligations. So interesting.
The governor in Kentucky really basically negotiated his exit from the institution, and investigations later raised, a lot of questions about whether he had been improperly receiving compensation or awarding compensation to employees from the university's foundation.
Yeah, that one, and you go back, I mean, in the Title IX, sex abuse setting, I mean, obviously Michigan State, I think it was Louisiana Simon, sort of similar issues. I feel like Michigan State comes on the horizon every couple of years around some issue like that. But yeah, so I vaguely recall San Jose State had an issue probably about 4 or 5 years ago. But yeah, pretty remarkable.
Yeah. The other thing that I think is important from this week is that the University of California is now being investigated by the Justice Department over its hiring practices. There are allegations that it improperly used race and sex to set quotas for faculty diversity, and similar, I guess, in a way to the announcement by the EEOC investigation into hiring at Harvard. What's your reaction to this?
Well, I mean, certainly this administration earlier made clear that this was a priority issue for them. And it's kind of post FFA concerns around, the best way to put it would be what is colloquially referred to as reverse discrimination complaints, and the use of DEI as a proxy, in essence, for having race-based preferences in employment. And obviously the Department of Education and this administration in general, including the Department of Justice in a variety of different contexts, but certainly here in higher education, has indicated that this is a real compliance priority for them. I can say anecdotally, without getting into any specifics, I am aware of the University of California investigation. I'm certain that they're not alone in that regard. And I anticipate there will be some other announcements about open investigation. And what will be interesting will be what the process is going to be in handling these. Again, in the past, when you had investigations around civil rights noncompliance, there were these long investigations. And the other thing, there was never any suggestion that we were going to, in the interim or even as a final measure, pull federal funding. Will this administration, much like they've done at Harvard and Columbia, say, first of all, we're going to be really quick about our investigation? And in the interim, or after a preliminary finding, will they pull federal funding, and or will they pressure institutions to resolve matters with the threat of pulling federal funding by making changes to the senior leadership of schools? So it's a long way of saying more of this is to come. Will be interesting to see what the tactics are the administration uses to obtain what in their minds is compliance with civil rights laws. And then will there be pushback? And certainly in a state like California, where the universities may be have some home court advantage in the courts, there may be some interesting pushback on this.
Terrific. Well, let's introduce our guest and get into it.
Sounds good.
Higher ed is facing headwinds like never before. And with internal teams leaner than ever, you need outside help that knows what you do and can plug into your operations to help in any way you need. From enrollment analysis and support, to bold, brand-driven creative and elite user-focused strategies, Electric Kite can help. So yeah, it's getting windy out there. But that's okay, because kites rise against the wind. Visit electrickite.com to learn more.
So today's guest here on Campus Docket is Courtney Bullard. She's the founder and CEO of Institutional Compliance Solutions. She can tell us a little bit about what that firm does. Before that, she was the Associate General Counsel at the University of Tennessee at Chattanooga. She has a BA in philosophy from Indiana U and a law degree from the University of Memphis. Welcome to Campus Docket, Courtney.
Great to be here.
Oh, and you know what? You're also the host of a podcast that's basically the same as ours, right?
No, it's not the same, but it's similar. Scott likes to copy me. I'm just kidding. Yes, host of Law and Education podcast, and Scott has been on it a few times. So it's fun to be now on his podcast.
I didn't know you were a philosophy major.
Yeah, I started as a chemistry major. So clearly went a different path. But yes, I was a philosophy major and a women's studies minor.
I think the world of Courtney, and really grateful for you to join us. Courtney is, to me, an absolute rock star in the education compliance space, and I'm really interested in getting your thoughts on a number of topics that I think are top of mind for a lot of universities right now. So thank you for joining us.
Well, I appreciate that, Scott. Back at you.
Well, before we get into the meat of the discussion, we do a little icebreaker with our guests. I imagine this is not the case on your podcast, Courtney, but you're here, and so you have to play by our rules today. And today's icebreaker question is, do you know your alma mater's fight song? And can you sing it for us?
By the way, Eric's inner authoritarian really came out just now. You're on our podcast. You will play by our rules.
Eric, of course I do. I was on the dance team. If I was feeling special right now, I would get up and do the entire routine for you. My dad could do it for you from watching me do it over years. So I definitely know the IU fight song.
You were on the dance team.
I was a red stepper, which is a kick line traditionally of 38 women wearing red boots. Yes, Eric. And the fight song, Scott's dying right now, but it is a fact. And so
This is the most amazing personal revelation anybody has made on our podcast today, don't you think?
It's a fact.
Somewhere there are pictures of this. I am going to find them.
Oh yeah, I'll send it to you. I've got bangs because that was what was in back then, and the red boots and the whole 9 yards. Yep.
Okay, so can you just sing a couple of bars for us of the IU fight song?
Oh my gosh, really? Let me think. Can I clap? Indiana, our Indiana, Indiana, we're all for you. You. To all my Hoosiers out there, they know what I'm saying. My husband's gonna be like, "Oh my goodness,
Go Hoosiers.
go!"
Awesome. That's great. That's great, Scott. Do you know your alma mater's fight song?
I was not on the dance team.
Scott, look at what I just did. You have to do something.
I don't know the fight song. I wasn't on the dance team. But I'll sing a random song.
I think I was just set up to look like an idiot.
I so needed that this morning. Thank you.
I do know my college fight song. I was struggling yesterday to think if I remembered I don't remember a high school fight song, but I do remember the Luther College fight song, and I'll sing just a little bit of it for you. You may know I started out as a music major, but this will not be reflected in my performance today. Our team goes in to fight and win. The spirit of old drives him on. With a pre-sec shout, we all turn out to yell for Luther, who wins today. Now that Luther's team is strong, we fight as long as victory remains in doubt. There you go.
You have the voice of an angel.
I have the voice of a failed tenor, is what I have.
Anyway. You sounded like an absolute angel. I can do my high school fight song. I know that one.
Could you? All right, yeah, let's hear that.
Are you serious?
Yeah.
Roll Rummel Raiders, red, white, and blue. Roll Rummel Raiders, ramble right on through. Onward and upward, we're flying high. The Raiders, something victory, it's written in the sky. We are the pride of the Southland. We're here to stay. Raiders, the champions, boldly show the way. Oh, we never give in till we get a win, and we'll win today. Rummel Raiders, shout hooray, fight. There you go. Thank you.
That was excellent.
And you clap too. See, maybe you're a cheerleader at heart, Scott.
I've often been told that. Yes, I am a cheerleader at heart.
Yeah, all the movements and everything.
Thank you.
Well, that's fun. Sadly, we have to move on from this very entertaining diversion. We brought you here today, Courtney, to talk about a couple of things about sort of federal compliance with Title IX and Title VI, two of the really crucial civil rights laws that hang over higher education and have been used in various ways to hold institutions to account. Some might argue to hold institutions unfairly to account or hold their feet to the fire. And I want to start today because we talked briefly on the podcast about the 2011 Dear Colleague letter. This was under the Obama administration. The Education Department sent out a letter basically informing colleges that many of them were not in compliance with Title IX, the law that ensures gender equity on campus, and laying out more or less what I think of as a series of demands for colleges to basically policy and practice demands that they had to comply with. A number of schools were brought under investigation in the years following, and this caused this was like an earthquake in sort of higher ed legal world. And I'd like to hear sort of your recollections on that moment, what it meant for higher ed. And then, of course, Scott, I know you have a lot of thoughts on this.
Yeah, so I was serving as general counsel in 2011 when the Dear Colleague letter was released. I say that it was kind of the start of the Title IX boom, for lack of a better word. I would venture to guess if you worked in higher education before 2011, the idea of a Title IX coordinator was completely foreign. Like if you were to call a university and be like, who's your Title IX coordinator? Some universities had it, some didn't. That Dear Colleague letter was the first time we saw a really strong focus on how schools respond to and address sexual harassment specifically. So House of Title IX, as I call it, covers a lot of things: gender equity in athletics, pregnancy discrimination accommodations, discrimination based on sex broadly. And then sexual harassment or prohibition on sexual harassment. So in 2011, there was this heightened focus once the Dear Colleague letter came out from the Office for Civil Rights. Their enforcement posture was ratcheted up, and we had this list of shame that was posted by OCR, on the interwebs of all the schools that were under investigation pretty quickly after the 2011 DCL hit. And really every school, including the one I was working with, was scrambling to comply with that guidance. Of course, it wasn't law, it was significant guidance. And at that time, I would say, I think Scott would agree with me, everything was really more complainant, or at the time what they were saying, victim, now survivor focused. So ensuring a process is fair and equitable, but also really trying to get folks who perhaps experience sexual harassment or sexual assault on campus to come forward to the institution and get the institution to address it. And it was very much higher ed focused, although it applied to K-12. What we really saw was a big push by OCR with higher education. So we saw a revamp of policies and procedures and training. We saw the start of the Title IX coordinator, which is significantly progressed over the last, 15 years or so. And really then has led to this politicizing, quite frankly, of sexual harassment on campuses, depending on who's in administration. That changes kind of what the expectations of schools. And I know we'll get to that, but that's where it all began in my mind, even though we had guidance way before.
I'd like to ask you a question about this. I remember this very significant NACUA meeting back when I covered NACUA. I think it was maybe 2012 when the head of OCR, Catherine Lehman, was there. The audience was very, frankly, hostile towards her, right? Very upset about this posture. If I recall, though, and you'll correct me on this, a lot of the things that OCR was asking for were things that were either in reg or statute, like the Title IX coordinator, that a lot of campuses had simply not followed through on. And yet, at the same time, the administration's stance was seen as sort of broadly overreaching. So I'd like you to, can you parse that for me a little bit?
You want me to keep going, Scott?
Yeah.
I could talk about this forever. Okay. So there was guidance. It's still out there now and effective in 2001 on all of this. But I think what happened in 2011 was, yes, I would agree. Most campuses felt it was an overreach, or that it was extremely broad and taxing on resources for institutions. It's kind of interesting to look back at that, because now here we are in such a different place, but the same place. And I remember being on vacation, getting on a NACUA call, and somebody, I forget what attorney, was breaking down how many musts were in the document, how many shalls, how many shoulds. So basically it really came across as you have to do this, even though it's a significant guidance. And of course, OCR was going to come after if you weren't. So that is my recollection as well, that it was pretty tense at the time and felt like a whole lot. I think now, had that not happened, we wouldn't have the focus that we have today. So reasonable minds could differ, but I don't think it was all bad by any means. Schools really did need to do a better job, but it has grown legs in a way that I don't know that any of us could have anticipated. But Scott, you might have a different opinion.
Yeah, no, I think it's interesting, especially for the time, to sort of unpack some things that happened then and how that may inform how schools handle things now. I mean, a couple of things that just jumped to mind. I remember at the time, I was in-house at that point as well at Tulane, and I was in meetings, and we were like, we need to comply. And one of the law professors in the meeting, was like, what is a Dear Colleague letter? And why do we have to comply? And it was kind of it's actually a really good, like, normally law professors don't help much. But on this one, it was kind of like, well, yeah, that's worth sorting through. Like, what is the significance of non-regulatory guidance from the Department of Education? And so we were thinking about those things 15 years ago. And now so much has changed, even in terms of regulatory guidance and the deference that's owed to that. So that was one of the questions, that really got me thinking. And, to this day, when people ask, well, the Department of Education sent out a Dear Colleague letter about DEI. What's the significance of this? Giving meaningful perspective on what that is and what the limits of that are. I think the second piece, you hit the nail on the head. And I know there's a lot of after the fact spinning of this, but the focus from the administration was almost unilaterally on complainants. And there was also this sense on a lot of campuses that we weren't doing enough to punish students who engaged in sex assault and sex harassment. And we had to do more. And it was very difficult during that time to say what needed to be said, which is, I am against sex assault, right? I'm opposed to it. I'm very much in favor of due process protections, especially for our students. And so what you saw sort of after that, there was much good. I agree. I mean, we handle these cases much better. The resources we afford students are fantastic, but there was clearly a run in that 10 or 5 to 10 year period where it felt as if at some schools, if you read the media reports correctly, that the students who had been accused weren't treated fairly. And so you saw this just surge in respondent related litigation that ultimately, I think, led to the 2020 regs, which was the contrast with the Obama administration has been very focused on the rights of students accused of sexual misconduct. That I think is a fair way of putting it. And then sort of going, all right, going through that experience, how does that inform our response to this initiative from the Department of Education around Title VI, anti-Semitism, DEI? And I feel like at some level, and it's maybe a good segue, this is sort of a redo of those issues in a very different context. But do you feel otherwise?
Can I ask one more backward looking question here, which I think will be relevant as we probe the now? I want to look backwards and I want to ask, why did no one challenge the 2011 DCL in court? In other words, there was pretty broad agreement that it was sub-regulatory guidance. It didn't necessarily hold a lot of water in terms of the regulatory and statutory requirements. Was there any consideration by institutions to say, you know what, we're going to push back on this, or would that have been just politically untenable at the time?
I don't know. I mean, to me, it was just such a different time. Like now we see all this pushback and all this back and forth. I think what we instead saw was so some schools just simply couldn't focus on that at the time. It took schools years to even come up to speed with what the 2011 DCL required. I mean, everybody chose their priorities, right? And most, in my opinion, I mean, this is anecdotal, didn't prioritize that until their feet were held to the fire or they were in the news or they were sued. So there were a lot who were like, okay, this DCL is out there. It's significant guidance, which is Scott's point. It's not binding law. And they probably weren't even intentionally, it wasn't even this intentional, but it was like, but I got all these other priorities over here that are happening on my campus. And so, I don't know. But all that to say, Scott's the litigator. He might have more insight on that. But I don't recall schools really talking about that. But that doesn't mean I don't know everything that was happening. So,
And I try to go back in time. I think some of it was politically, it would have been, and again, there's an analog to today, especially in red state publics. I mean, politically, it was very challenging, I think, to push back on that. There wasn't much appetite. And I'll also just say,
It was also the height of the Me Too movement.
yeah, that's exactly right. I will also say, and I don't know how to put this any other way, there became a conventional wisdom that grew around, you need to comply, this, da, 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 da. And people there was never anybody who came out and said, slow down, time out, no, that's wrong. And this is the reason why. So I think some of it was psychological. There was just this herd mentality. And again, the only time it was going to a meeting with law professors where they go, why are we so worried about complying with a dear colleague letter? And I couldn't thoughtfully answer the question that made me hit pause for a second. There was that, but it was also the moment, the politics of being opposed to the dear colleague letter would be framed as you're soft on sex assault or you're tolerant of sex assault, which is not a fair character.
That's what I was gonna say, like, it's very hard to come out and be like, "We oppose this, and we really don't care about people who are victims of sexual assault or survivors at our campus." Like, that would be a really tough. I mean, that's what it would be spun into, of course, and actually what it would be in some ways if you're to say, "We don't wanna do these things." And that just wasn't the environment at the time.
It was really hard at the time, and I feel like it's still hard at the time, at this time, to have like nuanced conversations about complicated issues because which is sort of so counterintuitive to me for institutions of higher education that of course we care about sex assault, but we have obligations to the students accused as well to make sure that they're treated fairly. Can we all come to some sort of way of looking at this that treats this issue seriously and provides sufficient protections for people who were accused? I don't know. There just it was a very difficult conversation to have at the time.
And we've seen some back and forth, as you guys alluded to. We've seen some back and forth on this. Obviously, the first Trump administration wrote its own rules around Title IX, giving much more deference to accused parties and requiring things like hearings, right? I think I'm getting this right.
Yeah, and you have to have a live hearing, and then you have to provide advisors to the parties.
Yeah, right. So there were a number of issues that came up that were controversial. Do we have have we struck the right balance yet, do you think?
Hmm. That's a $1,000,000 question. I think that just like in the 2011, where everybody was kind of like shock and awe, in 2020, in the middle of a pandemic, when these regs came out, which are still binding law, very different than the Dear Colleague letter. I think that was like, whoa, like that was huge and a lot of resource allocation for schools to. I mean, many schools weren't doing live hearings. Many schools had a single investigator model, and everyone was having to shift and redo policies and procedures. That was pretty big. And then we went through Biden administration enacting 2024 regs, which quickly were back to 2020. And I think that experience, I don't know, again, anecdotally, it was like, well, now that we actually have these regulations that at least tell us some prescriptive steps you have to take, that was kind of nice because it didn't feel nice at the beginning, right? 2011 Dear Colleague letter, there's a lot of gray and a lot of discretion on, there's all these things, but there was some discretion. There still is, but less discretion than there was. And so once we started working under the 2020 regs, it was like, well, there's 2 10-day review periods. You have to have a live hearing. You can't argue with these things. They're just law. So I think having some structure was helpful once we all digested it and started doing it. And then, but there are some things that aren't great about it for K-12, for example. So I don't know if we struck the right balance. I think it's nice to get settled. I just think it's too much back and forth for institutions to be effective in this area. It's like you're just changing the rules constantly. All that does is impact your campus community negatively because we can't focus on the right things: prevention, education, response. And instead, Title IX coordinators are just treading water. So like it, love it, hate it, it's nice to be back where the whole country is under the same law and we can kind of proceed accordingly for now.
So let's jump forward now. We had the October 2023 attacks by Hamas on Israel. Following that, of course, not widespread, but campus protests in a number of places that got a lot of media attention that in some cases were, destructive to campus property, right? Disruptive to campus operations. That was under the Biden administration, which responded by initiating a number of investigations under Title VI, right? And then, of course, President Trump wins re-election, and we see that sort of that sort of process on hyperdrive, right? My question about this is, what parallels do you draw to that? What comparisons are fair to draw between, say, the 2011 DCL and sort of the Trump administration's stance now on Title VI?
Hmm. Go ahead, Scott.
I'll kick it off. I mean, I say this. Look, I think I've mentioned this before. I mean, half my family is Jewish. I remember as a young child sitting with my grandfather and him talking about pogroms and so I'm enormously sensitive to issues, and you could just be a human being and be sensitive to issues around anti-Semitism. And it seems clear to me, like when you go back to the Title IX space, that there were instances prior to 2011 Dear Colleague letter where schools were not doing a good job of dealing with sex assault. And I think it's fair to say that there are a ton of schools in the aftermath of October 7th who weren't doing a good job of dealing with or responding to or supporting Jewish or Israeli students on campus. The concern I have is it's sort of the same concern. And in 2011, you started to be concerned about, yes, but rights of accused students of sex assault, sex misconduct. And here it's yes, but commitment to academic freedom, free speech on campus, the discussion of robust ideas, is criticism of Israel, for instance, inherently, and I obviously don't think that's the case, inherently anti-Semitic. There are parallels in my mind between saying, yes, we have to do more, and some schools failed in their obligations to protect Jewish students, Muslim students, right? We agree with that. But we also need to be careful here because certainly at public institutions, there are constitutional dimensions to this, and at private institutions, we think that, free expression is super important. So how do we balance these competing, at least in this context, commitments? Those, I think, are the parallels. Courtney, I don't know if you had any other thoughts on that.
No, I totally agree. I would also say all of it, sexual harassment, Title VI, allegations are just obviously very emotionally heightened, and they're really complex cases. I would even argue that for at least the team at ICS, we do a ton of Title VI investigations. We do as many of those as we do Title IX. They're really more nuanced and more complex sometimes than Title IX. Not to downplay sexual assault, obviously that's very serious, but you have cultural, and I mean it is pretty complex. And so when you're looking at it from a 10,000-foot view in a news article about how a university responded, as Scott's already said, it's so layered with constitutional law implications, but then also each case, there's just so much to consider that you maybe don't think about when you're stepping back as someone in the public watching what's happening at university campuses.
One of my questions about both the Title IX and the Title VI issues is that, look, we've had these laws for decades, right? And campuses have spent a ton of time, right, working out sort of like admissions and hiring processes, right? It's not like either Title IX or Title VI are new issues. And yet in each of these cases, I think campuses seem to be sort of caught on their back feet. I guess I wonder, is that just my perception, or is it just that they're responding to a kind of a sort of new pressure from the government that hadn't been there on these issues?
So what I'll say, and I'm sure Scott will have a lot to add to this, for us, at least like on the ground, practically speaking, when we're doing a Title IX training at an institution or a school district, Celeste Bradley on my team is the Title VI expert. She can talk about this much more intelligently than I can, but she always raises Title VI. Like, what are you doing? What is your policy and procedure? And 9 times out of 10, the schools are like, what's Title VI? Now, they might say, oh, wait, we do have an anti-harassment general provision in our code of conduct that this would fall under. But again, it becomes so nuanced in each case that I think I don't know that, I guess they're caught on their heels, but it's just the sheer volume that's coming in. So, like, you might have had a Title VI allegation here and there for sure, but now it is like the reports are up significantly. And so they're really trying to navigate a response in a fair way without solid guidance like we now have with Title IX. Like it's not prescriptive. It's not, it's mandated by law that you do something, but there's not as much out there. So to me, that's what I'm seeing. Of course, that's more practically speaking. I'm sure Scott will have more of a intelligent response about that. But in general, I'm like, we've been talking about this for a long time with schools. They just are having a hard time keeping up in general. Like higher education institutions, the big ones might have more resources and maybe not. It depends on who you talk to. But by and large, universities are like small cities. I mean, they're dealing with COVID. There's so many NIL. You name it, every legal issue you could think of is being handled at a university level, except for maybe a few. So it is one of a million things. And so all those competing interests sometimes conflict, or they don't even conflict. They're just prioritized depending on what resources they have. And unfortunately, a lot of times with institutions, just like in 2011, they have to get hit with something like an OCR investigation to really get the overall administration to pay attention to then put the resources towards fixing something, in my opinion. I mean, it's not to say some are out there doing a great job, but by and large, it's a lot of times what happens. But I don't know, Scott, you agree?
I mean, that is I think that's just a fantastic explanation. I'd go back probably a decade. I could be off by a year or two, but your former Senator Lamar Alexander had some hearings at that time talking about the compliance obligations for colleges and universities. And I said this, and I think you alluded to that this already. I mean, there's no industry in America that is subject to more compliance obligations than colleges and universities. And it runs the gamut from Title IV related compliance obligations, all the civil rights compliance obligations that we've been talking about, accreditation, FERPA, Clery Act, research compliance, labor and employment issues, all of that sort of stuff. And I think at the time, this was 10 years ago, Lamar Alexander, who I think was the Secretary of Education, I could be wrong at some point, mentioned it was like a jungle of red tape that, their institutional compliance obligations in the billions. And most schools don't have the resources to cover all of those at the same time. So it's a matter of triage, right? For the most part. I remember at NACUA one year, and this was post Penn State, the whole conference was about our obligations to protecting minors on campus. And you're like, holy moly, all these things we have to do. And there was a big focus on that for a few years. And then the Dear Colleague letter came. It's like, everything was geared to that. I mean, I continue to be part of what I think you talk about an area of non-compliance is probably around accommodating disabilities and issues along those lines. That could change. So it's just this enormous set of compliance obligations. And this has been discussed for 15, 20 years and kind of very limited resources in this constant state of, what are we going to concentrate on this year? And some of that's driven by the headlines, the legal issues, the compliance priorities of an administration. So I think that's the best answer. And, to Courtney's point earlier, I mean, I was at Tulane prior to 2011. If you walked around campus and asked who the Title IX coordinator was, nobody knew the answer to that. I'm not even sure. I'm quite confident there wasn't a dedicated person. Same thing could be said 3 to 4 years ago about Title VI. I mean, I'm not sure anybody even knew what Title VI was on campus, but now because of the protest and the regulatory focus at this point, this has garnered the attention. So that's where the focus is going to be. In 2 years, or 3 years or 4 years, a new administration could come in and say, we're going to prioritize Clary compliance. And people will be scrambling at that point to say, all right, we need to check our ASRs and make sure our crime counts are accurate and all that sort of stuff. It is just a robust maze of compliance obligations.
One thing that I think is significantly different between 2011 and now is that the administration is using, well, I would generously describe as sort of new and creative ways to seek to penalize institutions. We had Mr. Cunha on a couple episodes ago to talk about the False Claims Act in terms of Title VI compliance. We've seen the use of the threat and certainly the freezing of grants to institutions, sort of preemptive findings that institutions were out of compliance without really any real investigation. I would say I think that's fair. I guess, is there really any way that institutions can keep up at this point, given the sort of range of punitive measures that the administration is seeking to use on these issues?
I would just say that sometimes I feel like my role externally now and the ICS team's role is more therapist than consultant or lawyer. And frankly, it is funny, but it's true. And our clients, on the ground I would not want to be counsel on the ground at this point. It's a fascinating time to be a lawyer, but also trying to keep your eye on the ball is just untenable, especially with the pace within which everything is going under this administration, executive orders, lawsuits challenging, injunctions, no injunction. It is just a whirlwind. I don't have an answer to your direct question. I just would say that I empathize. And I think having community is helpful with other lawyers, which is things like NACU. I know we brought that up several times, but I think that's a super helpful space for those who are in-house counsel and really external counsel to join together, because collectively, I think most schools are, fighting the same battle, trying to keep up, trying to figure out the best response, where to prioritize, how to prioritize. And now I feel like at a more rapid speed than ever because of the kind of the posture of this administration and Office for Civil Rights on specific issues, not on every issue. It is just a wild time.
Yeah, the only thing I'd add, and I think that's spot on. Maybe I'm wrong. I don't pretend to have the best memory, but like 15, 20 years ago, when I would go to the NACUA annual conference, it felt much smaller than it is now. And so what you've seen in real time, and I think the one in Seattle, which I didn't have an opportunity to go to, I think the number I heard was like 2,000, 2,500, something like that, lawyers in attendance. So what you're seeing also, I've noticed, if I go back 20 years, I would say probably it was the exception to have in-house general counsel. Now it's very much the rule, and not just to have in-house counsel, but to have teams of people. And I've seen some universities now even hiring in-house litigators. So, you see anecdotal evidence of an industry under siege on a variety of legal issues. And it's selfishly, that's great. This is my business. And taking that aside, that is absolutely, it can't be healthy to have this many lawyers this involved in higher education. That is money and resources that, is going to lawyers like me or firms that could be reinvested into the core mission of an institution. But I don't see that trend slowing down. There's no political constituency at this point, Democrat or Republican, who, unlike Lamar Alexander 10 years ago, was saying higher ed is overregulated. There's nobody saying that at this point. It's quite the opposite. So it's a trend I've seen in real time over the last 15, 20 years. And it's a trend to me that's not going away. And I don't know that it's a particularly healthy development. And by the way, at some level, those costs probably are ultimately borne by the people who have to pay the tuition. So, I can't imagine for most institutions that their bottom line cost and tuition cost aren't going up.
I know, Scott, you wanted to ask Courtney about the transgender athlete issue. Why don't you set that up?
Yeah, I mean, I'm just kind of curious your thoughts. And I know this is one of these areas where the Department of Education, in the past, it was the Department of Education would take 18 months, 19 months, 2 years to investigate. And then, you get a consent or order or negotiated resolution or whatever. Here, it's like, we're going to do this quickly, which, okay, I mean, there have been a lot of advocates on the other ideological extreme who have called for this for years. I'm just kind of curious your thoughts on that issue and also the process that the Department of Education is going through to sort of penalize institutions for purported noncompliance.
I made a face just because it's such a sticky area, but it's also very straightforward from this administration. And I literally, before we started this podcast, was writing a Tuesday takeaway about this because we just had a new press release from OCR with respect to the California Department of Education. And literally, I just put this on my LinkedIn post, but it's the same thing. It's nothing new from the past couple of months as far as their approach, but it is going very fast. They're issuing press releases before anyone signs the proposed resolution agreement. And then it's like you have 10 days. And where the OCR case processing manual states you have, I think it's 90 days in order to review, negotiate, sign. And then what they're saying is they'll refer you to the Department of Justice. So far, I think what I could find was only one case that was recently referred to the Department of Justice, which was the one involving New York Department of Education and the banning of mascots and logos that celebrate Native American history. I'm looking to the right because literally that note is up over here that I wrote, but it is going at this warp speed. And so on the one hand, the message is we're dismantling the Department of Education and the Office of Civil Rights and removing all these employees and we're pushing this to the states. And on the other, you see this rapid fire, you're non-compliance, we're referring you, you're in non-compliance and we're freezing your funds. And so it's interesting. That's the word I'm going to use for today. It is interesting. I don't know what to say my thoughts are. I think it really depends on what state you're in or what your district or institution's position is when it comes to transgender participation in athletics and rights and all of that, as far as, who's getting targeted by this administration and as to being in noncompliance. But yeah, I'm going to stop there. I could say a whole lot. I'm trying to keep this non-political and just kind of stick with the facts, ma'am. But it's interesting. Scott, your turn.
Yeah, look, the only thing I'd add is, and I've said this before, I mean, like, I'll be a little bit political. This issue has captured way too much attention. Yeah, it is nowhere near in civil rights space. It is nowhere near an issue of critical importance. And look, which is not to say, I don't know how to put this any other way. There are really interesting questions and conversations to be had about women's sports, the participation of transgender women in women's sports, competitive fairness, all of that sort of stuff. But I've said this previously. The focus on this issue and kind of the crackdown on this without even, by the way, entertaining a nuanced conversation. I fault the other administration, by the way, for the same thing. I mean, I remember being at a conference, 8 or 9 years ago, and I think it was the Obama administration was, saying issues around high school bathroom access, and this is the way it's going to be. And I go, come on, can we have like a thoughtful conversation about this with both sides and reach something that makes some sense? But I've said this before, that this focus on this issue, it should make fair-minded people deeply uncomfortable. That's my opinion on it. Also, on the law, I honestly think they've got the law wrong on this issue. I mean, the and I have to argue this in about 3 weeks, but the law prohibits discrimination on the basis of sex. It creates exceptions, but presumably, if I say, well, I won't preview it yet, and I actually have to work on it a little bit, but I actually think they've got the law completely wrong on it. The other part of this that bugs me, and you see this, by the way, in like Western Carolina, is the department like completely ignoring the fact that either state courts or circuit courts of appeals have reached the absolute other conclusion on this, to say Title IX obligates you to allow trans women, for instance, to participate in sports or use women's bathroom. I mean, just come on. So
Yeah, Maine is a good example of that. I mean, there is this plenty of states that have competing state law with now what the federal directive is, which we saw in the reverse before. So, I agree, Scott. There's so many things to focus on that need attention in the higher ed space and the K-12 space. And this is really not where all the resources should be going.
And look, I know there are people, and I'm trying not to be too big of a jerk about it. I know there are people very passionate about this issue, and maybe rightfully so. But this just has struck me as just completely disproportionate. So that's my 2 cents here. Thank you.
I think the last thing we'd like to hear your thoughts on, Courtney. You work as an outside legal counsel or a consultant to a number of campuses, as does Scott. You've both also been in-house. That can be a tricky relationship. I'd like to hear your thoughts about sort of what are the pitfalls. Many colleges still need to use folks outside campus for their as legal resources. I'd like to hear your thoughts about sort of what are the challenges in navigating that relationship when you walk onto a campus and you have to give someone advice about how they're running their university or college legally.
Yeah. So we are more consulting and advising the practitioners, like the Title IX coordinators, the Title VI coordinators, the investigators, or we're serving externally in those roles. But we often partner with counsel, because it's a high risk area for institutions. They're certainly involved in it. And I think we're always very careful. And a lot of this is my takeaway from being in house, that we can kind of spot, oh, legal isn't involved in this conversation and they really should be. You need to talk to your legal counsel. We're not going to overstep on that. But there are challenges in my mind. I was telling this to Scott the other day, and Scott, I think, is doing a lot more litigation and we don't do any litigation. But where counsel has a very specific role on campus, right? They're there to help the campus make business decisions, but give them advice on the legal risk and watch out for landmines and all that. But there's that practical lens that's sometimes missing. And so they might be saying, well, you need to do something this way. You need to respond in a case this way. But practically speaking, it doesn't, number one, lead with care and support for the students maybe involved in that case. They're just thinking this is going to get us in a lawsuit, or this isn't, or even structuring offices or writing policies and procedures very legalistic instead of more user friendly. That's kind of what we run into, but we're always trying to be really clear on the front end, like what our role is and what our role isn't. And every single time we partner with an institution to ensure counsel's comfortable with it and to ensure they're at the table for any conversations that involve, legal advice or legal risk or what have you. But only other thing I will say, and this is from my lens, there's a lot of folks doing this work externally now, but not every single person out there doing the work externally has the experience in working in that area. I'm trying to say it as delicately as possible. So really ensuring that schools are partnering with folks, doesn't have to be my company or our team, who have that knowledge in order to do the work, because these are very serious issues with very serious implications for real people at schools. And so you want to make sure you've got the right people that you're partnering with.
Hey, I'm going to do an endorsement here. And this is,
Oh, an endorsement of me.
yeah, no, you don't even have to pay me for this. The number of people who have rushed into this space over the last 5 years. And what I will say, this is my endorsement. Courtney, her team, Betsy, Celeste. I mean, these are folks that know what they're doing, best in the business, really have experience. So people ever ask me who to recommend. I mean, they're definitely top of mind. So there, you don't have to pay me anything, but I did want to give you that PDA.
Well, and I feel the same way. Yeah, we've got, there's kind of this core group. We've been doing this for a while. Scott and I are in that, and I think there's no substitute for experience. So feel the exact same way with Scott. Obviously, he's an incredible litigator and has been in the space for a long time, as you can tell, because we're giving away how old we are. Everything today we've talked about is, 10 to 15 years ago and 20 years ago, we're dating ourselves, but we've been in it a while, and having that perspective is helpful. Understanding the evolution of how we got here, I think, is really helpful in partnering with schools, because a lot of folks we're working with are coming in brand new, maybe weren't practicing back in 2011 to understand, history and then kind of how that might shape where things are going. So I think all of that's really important.
Yeah, the one thing I'll add to, and this is something I'm pretty passionate about, is especially when we're dealing with students, which is often the case, the human part of this, the being empathetic, to not look at each one of these cases and not give the impression to any student that you're treating this as like, this is your visit to the DMV. This is an exceptionally, especially in the Title IX space, there are tons of regulations that can make this process less than humane, and having people that can be humane and treat people with respect, even when they don't get the result, both the right thing to do, right? It's consistent with the educational mission of the institutions we serve. It also is probably the best risk management strategy you could ever have. So I give kudos to Courtney and her team, because I feel like they treat these matters that way.
It's hard being a college or university president. Higher education leaders face tough choices, and the best path forward isn't always clear. Neither is how to communicate about the choices that an institution has to make. Trusted Voices explores the complex intersection of leadership and communication. Each episode, hosts Teresa Valerio Parrott and Aaron Hennessy chat with university presidents, industry thought leaders, and each other about the latest news in the industry and the challenges and opportunities facing those in the most visible roles in higher ed. Listen to Trusted Voices on the Volt Podcast Network, wherever you get your podcasts.
Terrific. I think that's a wrap. Do you have anything else you wanted to cover?
No, I wanted to say, I wish I could say all the same nice things about Eric Kelderman's journalism. It is terrible. It's the worst. He's no Sarah Brown. I'll say that right now. No, Eric's great.
Well, this was fun. Thanks for having me and allowing me to share my alma mater's fight song.
That was awesome. That's going to go down in Campus Docket history as a seminal performance. And I have to say,
I immediately regret that, but I'm just going to go with it.
Hey, what are your big plans this weekend, Eric? What are you excited about?
Oh yeah, that's the thing. We do like to wrap up with sort of what are we looking forward to. I have next week off mostly, and so a little staycation. Scott's promised me he's going to come up and help me put some new flooring in my basement, so that'll be great. Not true, actually. He's not coming, but he's welcome to. But I'll work on the yard and I'll work on the house a little bit and catch up on life.
And let me just say something. I'm a lawyer for a reason. I have no skills whatsoever. If you want me to help you with flooring, oh my God, will that be a disaster?
You could be the water boy. You could run
that, and I'm from Southeast Louisiana, so that would be
fitting. There you go. Right. Courtney, what about you? What do you got coming up the next week that you're looking forward to?
Well, we're going to the lake this weekend, and then my husband and I are going to Maine next week for a long weekend. So it'll be nice to get out of this heat. I'm excited about that. Yeah, just some time away. It's been a busy month.
Scott?
I am heading to, by the way, my friend Tommy Screen, who's a lawyer friend in New Orleans and an ardent fan of our podcast, has criticized me because he said, every time Eric asks you that question, you bring up music. And I'm like, okay, fine. So here, this Monday, my family and I were going to Japan for 2 weeks. And the thing I'm looking forward to the most, this is so pathetic. Me and my son are doing a samurai warrior experience. So I'll be sure to send pictures of that. But yeah, so 2 weeks Tokyo and then Kyoto.
I hope you both come back with all your like digits and limbs intact from that experience.
That would be the most boring story ever. Now, if I lose a limb or a digit, that would be exciting. Yeah.
Exciting is one word for that. Yeah, great.
Yes.
That's very cool, though. I hope you have a great time, but keep all your digits.
Will do. Hey, Courtney, thanks for coming on. This was great.
Yeah, thanks a ton. Really appreciate it. Great conversation.
Thanks, everyone. Talk soon.
There you go. Well, look, thanks for tuning in to Campus Docket. You'll find links to everything we discussed today, including related cases, articles, and a full transcript in the show notes and on voltedu.com. Be sure to follow Campus Docket wherever you get your podcast. And while you're there, check out Trusted Voices and Higher Voltage, 2 more podcasts in the Volt lineup that look at higher ed through different lenses. On behalf of the Volt team and my friend Eric Kelderman, thanks again for listening. We'll see you next time.